been informed by the interim city attorney that he needs additional time, maybe about 10 minutes, to work out a potential resolution with the appellant, I believe. So we're just going to give him that time. Just putting it on the record now, so everyone understands what the delay is. So just bear with us. Thank you. He's back on. All right. All right, Mr. Stokes, do I need to go through the entire script and spiel, or do we have a resolution here you want to
We
present?
have a resolution.
All right, go ahead.
May I approach?
Of course.
So as a matter of background, Mr. House was engaged in activity out in front of City Hall on August 1st and was asked to leave. He did leave. Okay. And, okay. He disputes whether he... He disputes that he was asked to leave. The police reports show that he was, but he disputes that he was. In any event, okay.
Sir, please let Mr. Stokes finish, and if you want to say something afterwards, you may.
Yeah, that's, thank you. He was issued a trespass warning, and what we have done, the trespass warning was rather broad. So I spoke with Mr. House and negotiated a modified trespass warning. Let him understand that the issue about like putting up the caution tape around City Hall and those kind of activities were not allowable and not protected as free speech, that it created a public safety issue because people coming by would think that there was some sort of emergency going on and that was the concern of the city. But that City Hall is a limited public forum, and so he is allowed to protest, and he can carry a sign, but he cannot affix anything to the building. Actually, there are several terms. If you'd like me to go over them, just put them on the record.
Not right now.
Okay. Well, in a nutshell, that's it, that he understands that he can protest, but he cannot affix anything to the building or to any of the poles or signs. He cannot block any of the walkways or the stairs or the ramps or the sidewalk or the parking areas with any temporary or permanent structure, and that he understands that he cannot have his motorcycle here with his music blaring to the point that it's heard inside City Hall and is disruptive. And at his request, and this is what caused a little bit of a delay, he wanted an additional provision as a condition to entering into this agreement, that he would be barred from committing any murder, mayhem, or assault and battery. Since he would be prohibited from doing that, that is paragraph number 8. But in any event, he understands that as a limited public forum, he can protest, but he cannot obstruct the operation and business of the city here at City Hall.
Mr. House, do you want to come up real quickly and again, we haven't sworn anyone in, so this isn't formal testimony. I just want to give you an opportunity because I think you objected to something he said. Very briefly, if you can just let me know, or so it's on the record. What was it that he said that you objected to?
That I was asked to leave.
Okay. All right.
There's record of even officers mentioning, so we didn't ask him to leave, right? In the video on the body cam. And they said, no, we're going to trespass him because he doesn't have any business here. Okay. That's going to be our grounds for trespass. Okay. And that's even on the video, and it says that. And there's even a witness to that here.
Sir, again, I'm just making sure we have everything about the settlement here. And I know.
Excuse me, sir. Did you not tell me to come up here and dispute anything that he just said? And
sir, not dispute. I just wanted to I wanted it on the record what you objected to. We're not at the point of taking testimony because, again, it looks like we have a resolution, so we don't have to do a full hearing.
I have a few more things to object to, though.
Yes, sir. Go ahead.
So all this is grounds of, saying that they trespassed me because of the caution tape that they claim was blocking a sidewalk. But yet, at the end of the day, all that incident was completely over. I drove around the block. I left the property without being asked to leave. And then I was involved in a traffic stop. After the traffic stop, I was very hot and in no condition to drive, so I simply walked over to City Hall and sat down on the steps in the shade. That is what I was trespassed for. not any of this other caution tape or anything else. So for the record, I want that to show that I was trespassed for being hot and exhausted and relaxing, even under the instruction of an officer to sit down and relax.
Understood. Now, this modified trespass warning that you did sign,
Because
you
it
had a
has
chance
everything in there that I wasn't doing anyways.
Okay.
Nor would I care to do, nor do I have any intent to do.
Okay, but we have.
So I agreed to the modification.
All right, understood, sir. Okay. Mr. Stokes, at this point in time, do we need to enter an additional order agreeing to the terms of this settlement? How would you prefer that it be handled at this point by the magistrate?
Yes, as part of the stipulation or this modified trespass warning, he does acknowledge that this will close his appeal.
Yes, sir.
So I would say even from the bench, if you accept the modified trespass warning and order it implemented, and then the matter be closed.
Okay, all right, I have no problem with that. So I have received this modified trespass warning agreed upon by both the appellant. I see he has listed as respondent, but I guess he would be the appellant, right?
Correct.
Okay, by the appellant, Mr. House, and by the city, or James Stokes, as acting or interim city attorney for the city of Titusville. This modified trespass warning will become part of the record on the appeal and will therefore close the matter. This document will be retained and is enforceable under the Florida statute for trespass if any of the conditions expressed herein are broken. I guess that's it, done and ordered. I have nothing further to add. Thank you, Mr. House. Thank you, Mr. Stokes, for helping us reach a resolution quickly today.
I have one question. This is in effect for 1 year, this modification of the trespass order. The original trespass order was for 1 year.
I think only the terms that are modified specifically in here are changed. The remainder of the trespass warning would remain active. Am I correct, Mr. Stokes?
That's correct. I mean, the city would have no problem saying that this is, in effect for a year, but as Mr. House points out, these are things that he wouldn't be allowed to do by law anyway, and he has acknowledged that, but this document expiring in a year is fine with us.
Thank you. Yeah. Thank you both. All right.
Thank you.
I believe that'll be it, and that will adjourn the hearings on the trespass appeal. Thank you all.